and gentlemen. Thank you for standing by. Welcome to the Expungement Policy and Practice in the South webinar. During the presentation, all participants will be in a listen-only mode. If you would like to ask a question during the presentation, please use the chat feature located in the lower left corner of your screen. If you need to reach an operator at any time, press *0. As a reminder, the call is being recorded Wednesday, November 5th, 2014, and I'd now like to turn the call over to Roberta Meyers. Please proceed.
Good afternoon, everyone. I am Roberta Meyers, also lovingly called Tony, in case you hear any of my fellow co-panelists call me by my nickname. Thank you so much for joining the New Southern Strategy Coalition for this webinar to discuss expungement and sealing policy trends in the South. We will highlight policy advocacy efforts in Maryland and South Carolina as they work to improve their current expungement laws and expand eligibility. Then we will move into hearing about efforts that are underway in Georgia and North Carolina to ensure people have full access to legal service support in lieu of their state's enactment of expungement laws back in 2013 and 2012, respectively. There will be a moderated Q&A session during the last 15 to 20 minutes of this event. But please note that throughout the course of the webinar, you will have the opportunity to submit your questions through the chat function on the left side of your screen. We will work to address your questions during the Q&A portion. However, all of our contact information is available on the PowerPoint, and you should feel free to contact any one of us after this event. We will be emailing the slides and the link to this recorded webinar to all registrants after the webinar. Note that your sound quality, if you're listening online, is dependent on your own internet connection. If you have sound quality issues, send us a chat, or you can look in the chat function and the 800 number to call in is available. We are hoping that this webinar will let you see that you are not alone in trying to help people overcome their past criminal histories, and that policy advocacy and direct legal services are ways to ensure people get the opportunities and second chances that they are looking for. We're here to share our knowledge and experiences and hope you will join the coalition to do the same. I wanted to do a quick general overview of the policy of limiting access to criminal records before we get to my fellow co-panelists who will get into the details of what's happening in their states. There are many differences to note in reviewing these policies nationally. In our analysis of expungement and sealing policies in all 50 states and in the District of Columbia, we recognize that there were several different terms that are used to describe this legal remedy. Some places use the term sealing, expungement, erasure, purging, and also shielding, or some combination of terms for different effects and remedies. Then there are differences in eligibility for the procedure. Some states only allow individuals with non-convictions, those individuals that in the end have not pled guilty or wasn't found guilty of an offense. Some states also offer expungement or sealing of convictions that is predicated on the seriousness of the offense or the amount of time that has passed. Differences in effect and remedy are crucial information for the individual. Often people look to expunge their record so that they never have to worry about their record being given to an employer or other background checking source, and they often want to be able to deny having a record so that the stigma is lifted off their heads. But there are many laws that fall far below those expectations, so it is critical to understand the impact of these policies in your state. Finally, the process differs. Some people have to go back to court and file a petition. Some courts charge filing fees. Sometimes the prosecutor has to be notified and approved, and in some places it is automatic for non-convictions. These processes can differ not only state by state, city by city, but county by county. So when considering advocating to create or improve expungement or sealing policies in your state, there are many factors to consider in the process or in the legislation in order to make sure the policy works and is available to whomever the remedy is being created for. The best resource for up-to-date information regarding this remedy is through Margaret Love's research that is housed on the National Association of Criminal Defense Lawyers website. But to do a quick summary, 45 states have some sort of judicial sealing or expungement process in place for arrests that didn't lead to conviction. Georgia and Tennessee are the two states in the South that have most recently passed legislation. You will hear about Georgia from Doug a little bit later during this presentation. But Tennessee added a provision in its law that an individual who receives a pardon has grounds for also qualifying for expungement. However, I am also highlighting Tennessee because it is an example of how an expungement law exists but may not help many people. If individuals have more than one conviction, they are not eligible to apply for an expungement at all. Not to mention, the expungement provision in Tennessee significantly limits eligibility, and it costs $350 to file a petition, which further diminishes access to the remedy. And I'm sorry to have to call out to all Tennesseans. I'm not picking on you only. There's lots of other states that need work as well. There are 4 southern states that allow expungement of convictions: Kentucky, Missouri, North Carolina, and South Carolina. Each state is different, and there are many limitations in the laws, but they do exist and help some people. But I also think it is important to point out a very interesting trend in the South. There are a significant number of southern states, 8 in total, that gives what I will call a first chance to people by offering deferred adjudications for criminal offenses. Usually, if the individual completes probation, and it's usually probation, his or her case may be expunged. That isn't something you see in other parts of the country. I'm guessing that this may be one of the reasons why these states are often hard on giving second chances. So we can talk a little bit about that in another event. But I'm sure there are lots of other reasons that we don't have time to get into today. But I thank you for listening, and I hope you enjoy the rest of the presentations. I'll turn it over to Caryn now.
Caryn, you may be on mute.
Hi. Hi, everyone. I'm Caryn Aslan with the Job Opportunities Task Force. JOTF that's what our acronym for Job Opportunities Task Force. We're a statewide independent nonprofit that focuses on improved wages and economic opportunities for low-skilled, low-wage workers. More specifically, we support policies and programs that help low-wage workers advance to high-wage jobs, particularly those with a criminal record. For years, JOTF has worked with advocates across Maryland to improve policies that seek to remove barriers to employment for those with a record. And one tool that we have focused on, our efforts on, is restricting access and use of the record by employers and landlords, such as expungement. Today, I will focus on Maryland's expungement laws and our efforts to expand relief. So, expungement in Maryland. Currently, how expungement is defined in Maryland is the complete removal of criminal records, including some civil citations, from public view. This means no one retains access to the expunged records. Many states who do have expungement laws allow certain entities, such as the courts or law enforcement, to retain access to the record. In Maryland, an expunged record provides access to no one unless there is a court order available that would allow access to the record. What can be expunged? An acquittal if you receive a not guilty, an arrest without charge, a dismissal, cases that result in a probation before judgment, except DUIs or DUIs. If the state's attorney declined to prosecute, such as also called a null pros, a STET, which means that the court indefinitely postponed the case, a full unconditional pardon by the governor for only one nonviolent criminal conviction, convictions of common nuisance crimes, which I'll talk about later, and adult cases that were transferred to juvenile courts. So just a breakdown of the different offenses that are eligible for expungement. I mentioned before arrest without charge. That means that if you were arrested but ultimately were not charged, meaning you were released and not charged, your record would be eligible for expungement. Now, if you were arrested and not charged on or after October 1, 2007, then no action is required by the individual. No fees, no filling out of a petition, none of that. It is an automatic expungement. However, if you are arrested prior to October 1, 2007, and no charges were filed, it is not automatic. You must still file a petition. It must be within 8 years of the arrest, and if the petition is granted, there is no fee that is imposed, and if your petition is denied, it can be appealed to the district court. For favorable dispositions, or what we like to call non-convictions, they are also eligible for expungement. So acquittals, null process, and dismissals are only eligible for expungement if the individual waives their right to sue, and this is within 3 years. So if you receive an acquittal or a null process or a dismissal, you are eligible to petition to have that favorable disposition expunged that day or any time within 3 years if you waive your right to sue. If you decide not to waive your right to sue, you must wait 3 years until that acquittal, null process, or dismissal is eligible for expungement. It's different for probation before judgments, PBJs, and STETs, whereas the 3-year general rule kind of outweighs any other rules. So if you receive a probation before judgment, but say your probation is only for 1 year, you must still wait 3 years before that probation before judgment is eligible for expungement, because the 3-year period is later than your year of probation or your probation period. The same with the STET. You must either wait until you complete your alcohol or drug treatment or any required treatment program, or you must wait 3 years, whichever is later. For guilty convictions, there are only a limited number of what we call common nuisance crimes that are eligible for expungement, and I listed a couple there: public urination, panhandling, what we like to call crimes of homelessness. Those are eligible for expungement after a 3-year waiting period. You must file a petition, pay $30. The state's attorney gets a copy of the petition, has the opportunity to object, and if the state's attorney does not object, then your petition is granted. If the state's attorney does object, a hearing is called, and the judge ultimately makes the final decision on whether or not that guilty conviction is eligible for expungement. If you were convicted but you were found not criminally responsible, the only offenses that are eligible for expungement where you were found not criminally responsible are trespassing on posted property, disturbing the peace, and telephone misuse. Also, again, if you received a full unconditional gubernatorial pardon for one single guilty conviction, that is eligible for expungement. Limitations to the current expungement law. As I mentioned, there's only a limited number of criminal convictions that are eligible for expungement. If they are outside of the 11 common nuisance crimes that are eligible, or if it is not a full unconditional gubernatorial pardon, then that conviction is not eligible for expungement. The unit rule, which I am pretty sure many of you are aware of, this rule is the idea of if you have several charges and are convicted of one, and one is eligible for expungement, but neither of the other offenses are, then you cannot expunge any of those. Another limitation to Maryland's expungement law is what we call the subsequent conviction rule. That means if you are initially charged with an offense, if you receive a null process, PBJ, STET, or a pardon, and you are subsequently convicted of another crime, it could be even more minor than your original offense, that prohibits you from expunging the initial eligible favorable disposition. A pending criminal case also prevents you from receiving an expungement. The process. So as I mentioned before, the process is pretty simple. You would have to obtain necessary forms from the court or from the court website. Unfortunately, you do have to file the forms in the court where the case was heard. Again, the state's attorney gets a copy. The involved law enforcement agency gets a copy. There's a $30 filing fee. Individuals are eligible for a fee waiver if they are able to meet certain conditions. The state's attorney has 30 days to object to the petition. If they don't object, the petition is granted. If they do object, a court hearing is called, and the judge ultimately makes the final decision. process takes up to 120 days or more unless the state's attorney objects. Each agency involved has 2 months, up to 2 months, to comply with the court order expungement, and the petitioner should receive a certificate of compliance from the agencies. Now, the challenge to Maryland's expungement law is this thing, one of the major challenges is this thing we call the Maryland Judiciary Case Search. The Maryland Judiciary Case Search is an online free tool that allows individuals to access Maryland criminal record history I've seen some from all the way back to the 70s. Once again, this is an online free tool, so anyone who has a computer or a smartphone is able to access anyone's criminal information. As I mentioned before, many eligible non-convictions are not eligible for expungement, whether it has to do with the fact that you were subsequently convicted of something, whether individuals are not informed on the expungement law. Many don't know what's eligible for expungement and what's not. The $30 fee is a barrier to many being able to apply for their expungement, and the process in itself, having to go to the courthouse and obtain those documents and ensuring that you're filling them out correctly. Another challenge is also many minor dated criminal convictions are not eligible for expungement. So outside of those common nuisance crimes, many criminal convictions are just not eligible. Also, the Maryland legislature is reluctant to expand the existing expungement statute, and that has to do a lot with how Maryland defines expungement. Again, expungement in Maryland is the complete obliteration of the records. No one has access, and many legislators and many others, many key decision makers and stakeholders in Maryland are very reluctant to expand a law that would prohibit access to a prior record. So the solution: to reform Maryland's expungement law, obviously. In 2015, Job Opportunities Task Force will work with many other advocates across the state on 2 important pieces of legislation. The first one would be it would be a reintroduction. It's been introduced in years past, but it would be our first year introducing it, and it has to deal with the immediate expungement of favorable dispositions. Okay, these are your null process acquittals, dismissals, PVJs, and STETs, and the repeal of the subsequent conviction prohibition, meaning if I receive a favorable disposition and am subsequently convicted of something, my favorable disposition should still be eligible for expungement if the law allows it. We'll also be reintroducing for the 4th year the Maryland Second Chance Act, which I will talk about later. So the history of shielding, which is kind of the definition of the Maryland Second Chance Act. Shielding is different from expungement in that shielding retains access to the shielded record for law enforcement, courts, and certain employers that might have some legal, statutory, or contractual obligation to inquire into an individual's background. Shielding was first introduced in 2012. It was a recommendation from the Maryland Governor's Task Force on Prisoner Reentry. It was a very bold proposal. We proposed the automatic shielding of nonviolent misdemeanor and felony convictions after a 3 to 5 waiting period while maintaining access for certain entities. Any eligible subsequent convictions would restart the clock, meaning if you were convicted of a misdemeanor, you satisfied any mandatory supervision to the state without being subsequently convicted, you would have to wait an additional 3 years to petition the courts. And within that time, if you were subsequently convicted, then you would have to wait an additional 3 years before that eligible conviction would be eligible for expungement or for shielding. That did not pass. We came back in 2013, instead of focusing on felonies, which is focusing on shielding nonviolent misdemeanors, and also instead of having it being an automatic process, it would be a petition process. That was the 2013 proposal. Previously mentioned entities would retain access. Employers, law enforcement agencies, and the courts. Subsequent convictions, again, would restart the clock. But this year, in addition to it being amended to a petition process and only nonviolent misdemeanors, it was amended to only allow for the shielding of 20 offenses chargeable by citation, meaning instead of being arrested, you would be issued a citation. That bill died also. In 2014, this past legislative session, the Maryland Second Chance Act of 2014 was reintroduced. And again, it focused on nonviolent misdemeanor convictions, and we focused on a very small number of nonviolent misdemeanor convictions, those with high arrest numbers such as theft under $1,000, drug possession, disorderly conduct, things of that nature. The same entities would maintain access, law enforcement courts, those with a legal, statutory, contractual requirement, and it definitely received a lot of broad-based support from many state elected officials. However, it died in the last minute due to many other various reasons that I will talk about later. So some of the challenges to why it is taking so long to pass shielding in Maryland is for a number of reasons, and I like to call it the uphill battle. In Maryland, our General Assembly tends to be different from a lot of other states. Our legislative session is only 90 days. That means that advocates from around the state have 90 days to convince legislators to focus on their particular issue and give it the time needed to make sure that the issue is legislated properly. So within that 90 days and over 3,600 bills that are introduced, you have many competing issues, whether it's from the entire General Assembly or whether it's from your two main committees. These issues tend to go to our Senate Judicial Proceedings Committee and our House Judiciary Committee, which deals with a lot of very controversial, important issues, but it tends to be pretty conservative when it comes to criminal justice issues. Also, if it's an election year, it's very tough to get pretty much anything passed out of the General Assembly because obviously folks are focused on their respective elections and how any votes that are given or any bills that are passed, what type of impact that is going to have on the passing the bills. Some other issues or challenges would be, of course, law enforcement, the Maryland State's Attorneys Association. Even though with shielding, law enforcement would maintain access, they still have a general philosophical opposition to these type of issues. Business community, domestic violence advocates, and just the general perception of restricting access to the records. So what are our next steps? Once again, our next step is to introduce shielding again in 2015. It's going to be very similar to the 2014 legislation. It would restrict it to a certain number of misdemeanor convictions. I've listed a couple there. The waiting period would still be in place. Certain entities would still retain access to shielded records, certain authorized entities, and the process remains similar. It would remain similar to the current expungement filing process. Expanding access to expungement for charges that don't result in a conviction. Those are our favorable dispositions, and repealing of the subsequent conviction rule. Those are going to be our two major policy initiatives. Outside of ensuring that folks support these initiatives, we have to raise awareness around the idea of the impact of the record. And that includes things like what we do, our Reentry Day in Annapolis, where we bring hundreds of individuals to talk to legislators, kind of talk about how the record impacts their life, and kind of wrap in grassroots efforts in this process and these initiatives to make sure that everyone's story is told and interpreted. So if anyone wants any more information about our efforts in Maryland and what we have done and what we are doing, whether it's regarding shielding or expungement, you can please feel free to contact me. My contact information is right there. And now I'm going to turn it over to Ms. Ashley Thomas with South Carolina.
Thank you, Caryn. Like she said, my name is Ashley Thomas. I'm a staff attorney with the South Carolina Appleseed Legal Justice Center, and we are a policy and advocacy organization that works primarily on issues facing lower-income South Carolinians. And the criminal record piece is something a little bit new to our organization, but it's something that we think is very important to focus on, especially since these criminal records tend to keep folks in a place where they can't really get outside of the current economic situation they're in. So we're kind of at an interesting point in South Carolina here. And as Caryn said, her legislative session is very short. Ours here in South Carolina is a little bit of the opposite, and it's very long, which sort of presents its own challenges. We have a 2-year session. It goes from January to June 1 year, and then there's a 6-month break, and then January to June the next year. So as you can imagine, that sets some issues in play as far as getting legislation passed and not letting it just languish and die. And that's a picture of our beautiful State House, and you can see there's a wonderful flag flying out front, which is another one of our hurdles going forward. And just as a little bit of background, in the last few years, we have been doing a lot of criminal justice reform generally, in part because our prison population is just skyrocketing, just like many other states' prison populations were skyrocketing. And so our legislature decided they wanted to do something about it, and so they passed a law in 2010 that basically kept low-level, nonviolent offenders, drug offenders, property crimes, things like that, outside of the prison system, stopped violating people for technical violations on their probation and parole, things like that. And it was a huge success. So there's a lot of goodwill that came from that. Prison closed. The state saved a bunch of money, so everybody was very happy about that. Despite some fears that it was going to cause all sorts of problems. Crime rates went down. It was all in all a great thing. Around the same time, they worked on the current expungement laws. They didn't do a lot to it, but they did make some improvements. The Youthful Offender Act, the YOA expungement time period, wait period, was reduced from 15 years to 5 years. And I'll go into that a little bit more in a future slide. And removed the fee for expungement for non-pros charges, which was great. However, what's not so great is they have had lots of confusions about how to interpret the laws. It's all over 15 different statutes. It's a mess. The Attorney General's office has been issued 9 different opinions trying to clarify. And in some of their opinions, they're like, we really don't know the answer to this. The legislature has to fix it. So they're trying again. But our current law here now is not as bad as other places in the South. For non-convictions, those can be expunged immediately. There's no fee. There's no wait period. So any sort of acquittal, dismissal, null pros, things like that. We have quite a few diversion programs, and at successful completion of those, you're allowed to get those charges expunged. I'm going to highlight the bad check charge because that's going to come up a little bit later. Currently, for a first offense bad check charge, you can get that expunged. It sounds bad, fraudulent check, but it's really like bouncing a check and not being able to pay it within a certain time period. We have this law called failure to stop for a blue light, and for whatever reason that's included as an expungible offense, and that's basically not pulling over when a police officer tries to pull you over. I'm not sure how that got in there, but it's there. Conditional discharge is a system for somebody pleading to a drug charge, and then they pass 2 drug tests, basically, and then if they do so, they get their charges dismissed and expunged. That's great, but you have to have a judge order you to a conditional discharge in order to take advantage of it. The first offense misdemeanor conviction is pretty broad. It covers a lot of different things. There's a 3-year wait period for most misdemeanors, 5 years if it's a criminal domestic violence charge. I think that's fairly advanced for a lot of the states in the South. Youthful Offender Act is really the only way to get a felony expunged. It's for nonviolent felonies. It's for offenders who are under the age of 25, and they have a 5-year wait period before they're eligible. Again, a judge has to sentence you under the Youthful Offender Act. So I'm going to highlight that because that's going to come up later as well. Certain nonviolent juvenile offenses are expungible. Now, this last part, the cost, is a major issue. As you can see, it's expensive. $250 goes to the local solicitor's office, the prosecution. $25 goes to the law enforcement division, and then $35 goes to the clerk of court. So the total is over $300, which is prohibitively expensive for so many people. And there's a lot of people who are eligible but just cannot take advantage of the current expungement law. So what do? They've decided that they wanted to work on these expungement laws. So this past session, there was a joint resolution to create a bipartisan expungement study committee, basically, that was going to meet over the summer and the fall and issue a report to the General Assembly, hopefully to bring about some new legislation for the next 2-year session. And so we got involved with that, but it wasn't just us. We decided we needed to bring in other stakeholders, some directly impacted individuals, people who work with folks who have criminal records, employers. We just needed to have a lot of voices in the room so that it didn't seem like it was just an aberration that we wanted things changed, that we wanted to show that there were a lot of people who wanted things to change. And they were very open to it, which was great. So we, before the hearing started, we had some meetings and we kind of developed a strategy so that we would each ask for similar things but not necessarily the same thing. We wanted to overlap some, but we wanted it to seem like there was a broad base of support for this positive change. We submitted written testimony prior to the hearings, and we also presented some oral testimony during some of the hearings. This is Pat Littlejohn. She is the executive director for Center of Fathers and Families here locally, and that's her testifying. Because we really did want to make a bigger impact than just, me getting up there and saying something. These were the South Carolina proposed changes from our organization, South Carolina Appleseed's proposed changes. The primary one is to reduce the fees associated with expungement, because it's all great and wonderful if everything can be expunged, but if you can't afford it, it doesn't do you any good. We don't even have a slating scale or a waiver, so that was one of our suggestions. There was a number of people from court administration who opposed that. They wanted to increase the fee, explaining, especially with the change of law that would allow dismissed charges to get expunged for free. They were talking about how many of those they process, and which is an issue of, why are the police arresting so many people if these charges are ultimately getting dismissed? But, that's a whole other issue for another day. So they kind of want the cost increased. Our argument was to decrease it, and we're not sure exactly what's going to happen with that. With the Youthful Offender Act, we wanted to expand those eligible charges under the Youthful Offender Act, but not make it so that the judge has to sentence you under the Youthful Offender Act. So basically, if you're under 25, you have a nonviolent offense, it's your first time, you wait 5 years, and there's no other convictions, then you should be able to go back and get that expunged. Our judges all do things differently. Defense attorneys use different methods to get, their clients' charges resolved, and not everybody uses the Youthful Offender Act. I wish that more people did, but not all judges like it either. So we want to just make sure that even if you don't happen to get sentenced under that you could still take advantage of that. And a similar thing with the drug offenses. Currently, you have to be sentenced under the conditional discharge statute in order to take advantage of it, but we wanted to open it up to all first-time minor drug possession charges, small amounts that were used for personal use, things like that. And with the fraudulent check, we asked that they allow multiple bad check charges to be included instead of just one. We'd have to come up with some sort of time period, just because you bounce one check, and often it's not the only check you're going to bounce. So we wanted to make that provision a little bit more useful. So the report was issued October 13th. While the committee was very open to suggestions and wanted to expand the expungement law, the report was not as strong as we would have liked. There was 3 main recommendations, which was to develop a stakeholder task force, to pre-file some legislation, and to reestablish the expungement study committee in order to help get that legislation through, and then task the different committee members with getting the bills through the different committees, because it is a 2-year session, and so things tend to just go away and die unless somebody's really working them. They did make a list of all of the recommendations that were made by the various people who provided testimony, either written or oral. So all of our recommendations did get through to that final report. And I've contacted, the people in charge of the stakeholder task force, and I've asked to be on that task force. But at this point, we're just not sure what's going on with that. So that's where we are. We're kind of in the middle of it. We're at the cusp here. I do think that the positive response to the general criminal justice reforms that have happened over the last few years has opened up people's minds to sort of looking more closely at expungements, and also just the cost to society of having this group of individuals who basically can't work or work very low-paying jobs, and that affects everybody. So with that, my contact information was earlier in the slide, but if anybody has any questions or would like to chat about that, I'm open. So now I think I will turn this over to Doug with the Georgia Justice Project.
Thanks, Ashley. This is Doug Ammar in Atlanta, and let me just, this is a transition in our webinar, and now we're going to be talking about if you get some laws passed, if you're successful, like the folks in Baltimore and like the folks in South Carolina, to move the needle and get some restrictions in place legislatively, the real question becomes, how does that show up for people on the street? And so Daryl and I are going to talk about our work on a direct service side of the work and an education side of the work about letting those laws sort of hit the street and letting folks have the opportunity to feel the impact, the positive impact of those laws. So I'm going to do a couple things. I'm just going to say a little bit about the organization, and then I'm going to get into the meat of what we do and how we do it, I guess. First of all, hopefully you're all on this call or on this webinar because of the New 7 Strategy Coalition, which the premise is it is really bad in the South, and it really is. Georgia, we sit right in the middle of some of the worst, as this slide shows. We have about 1 in 3, almost 4 million people in Georgia have a criminal record. As you all probably know from the Pew study, that Georgia is the highest in the country for folks under correctional control. According to our good friends at the H.I.R.E network, Tony's work, Georgia has been ranked, unfortunately, second worst in the country if you have a criminal record, how it can impede your ability to move on with your life. And specifically, according to their quantitative data, we are the worst regarding that issue for employment. And of course, all this stems back to issues in the South, its connection to the criminal justice system, and that's, again, a topic for another conversation. So the Georgia Justice Project, here's a quick slide to sort of show you our work in a quick way. We're really premised on direct service, but we've gotten into policy and education and coalition building around the issues of criminal justice. More specifically, the next slide I'll say that we as an organization, we are about 28 years old. We're located in the King District in Atlanta, and we really divide our work up a couple different ways. One of the easiest ways is to talk about our direct service. And the first thing we've done the longest is to represent folks on the front end of the system as a private, non-court appointed lawyer, follow our folks into the system if they get convicted. If they go to prison, we stay with our clients and their families and help folks when they get out of prison to get back on their feet. And out of all that work, a number of years ago, we got more committed to the issues of criminal records, and that is, we call that work coming home, which I'll talk about in a second. And of course, out of that work, out of the coming home work, the criminal records work, we decided to focus on trying to change some laws in Georgia. Again, I'm not going to talk about that here, but that work for us, the policy work, is really rooted in our direct service. We are really had the great fortune to sort of win some good victories in the last few years, and we approach it from a really problem-solving sort of perspective, not just pointing out the problem, but really coming up with solutions. And we've been really fortunate to work with, in Georgia, the governor a few years ago started the Criminal Justice Reform Council, and we've been fortunate to be able to work with them. All right, so now let me move on to really what we do on sort of the direct service side. Again, if you get some laws passed, great, but you've got to, if those laws to have effect, have got to show up for folks. So we call this part of our work coming home, and it's really divided into a couple different ways. And the first is direct service, direct representation. And as lawyers and as volunteers, we work with folks on expungement, restricting folks' records, correcting them, and also counseling. Part of our work is multidisciplinary. We have social workers on staff, and that's also been part of our work long term, but we also realize that's part of our working with people. I would say, too, that we just recently started a volunteer legal clinic just a few months ago. We've been planning it for a year or two, but it finally hit the ground. And I left off the number served, forgive me for that. But in terms of direct service, last fiscal year we represented about 500 folks on this side of the work, or a little bit under 500. The education and training part, the other thing we've learned is that if you get a victory in the State House and you're able to change the laws, you also have to, it's helpful to have an implementation strategy, to put the word out there. And so we started doing that a few years ago, and we've done a number of trainings all over the state with the CLEs, continuing legal educations, and working with judges and nonprofits and directly affected folk. We see that work is really a way of supporting the policy work, recruiting more people. It also is a part of our self-help sort of aspect. As you remember from the first slide, there's over 4 million people, or roughly 4 million people to record. We cannot represent 4 million people, so we've got to put the word out there how to help folks, without necessarily relying on us, since we're the only group in Georgia that does this kind of work. So to give you a sense of scope, last fiscal year we did almost 60 presentations touching about 2,500 folks. And advocacy, again, part of the work of changing the law, which I'm not going to get much into. All right, so let me drill down now on sort of 3 aspects. The next 3 slides, the final really 3 or 4 slides here, are just about how we show up for people. So the direct representation side of our work, which is, again, this is focused on our staff. We have a staff of folk who will handle a number of these things on this list, restrictions and corrections and those kinds of things. Folks come to us, a lot of referrals from other nonprofits. We have a screening process, and the doorbell's usually always ringing, and the files are usually backed up for us trying to help people. But we started that part of the work, the direct service side of that, really in 2008. And out of that work, we realized that it would be great to sort of have an opportunity to have volunteer lawyers engage with us. Since our work we've done the longest is front-end direct criminal representation, that's a bit hard to train a bunch of corporate lawyers how to show up for a bond hearing or an arraignment on a robbery case. But it isn't that hard to train lawyers to come in and help us on an expungement or restriction case. So starting a few months ago, we host a clinic the second Friday of every month. We're pre-screening clients. We usually are trying to get about 10 to 15 folks in the door, clients that is, every time. We've been working with a number of the large law firms and corporate legal departments here in town. And we have a training, a 2-hour CLE we've done. We've now scheduled. We've done one. We have the next one scheduled for January, where we recruit lawyers, sign them up, 6 to 8 lawyers per month. And that's been going quite well. And they've been, I think, having good experiences. And we've been able to, of course, increase our caseload and increase our impact, which is part of the point. We also have hired a part-time person who's a lawyer to really coordinate that work. She has her own caseload, so she knows the work, is getting used to the work, so she can answer questions from her volunteers. But the idea of having somebody in-house who's trained as a lawyer has been very, very helpful for us. And I also have to mention that we produced a number of materials. I don't have a slide to show our wonderful manual that our lawyers have produced, but we have a manual that is also available on our website that is a great training tool for our lawyers, and we give to other nonprofit folks as well. And then the last really substantive slide here is just talking about the training and education component. Again, I talked about the manual just now, and I referenced at this point about our web presence. All of our material on in the manual is on our website, and we have it divided under our frequently asked questions. And we just checked recently, and I think over the last year's time, we had 90,000 hits on that part of our website. Again, we recognize that we cannot represent everybody, but we want to make the information available for folks. And that's part of the reason we do these presentations all over the state, to put that information in people's hands, lawyers as well, volunteers, but just the folks who are affected so they can access things on their own if they can and be more knowledgeable. And again, also those presentations serve as a tool to loop people back into the policy work. So in many ways, the direct service, the education, the policy work all work together to sort of bring about change in the state. And I mentioned that we posted a few lobby days. The last slide here is just a picture in our office of a recent training. I believe that's Brenda Smeaton, who some of you know, training a bunch of folks. So with that, I'm going to stop and turn it over to Daryl Atkinson. Daryl, are you ready?
Yeah, I'm ready, Doug. Thank you for handing it off. I'm Daryl Atkinson, Senior Attorney with the Southern Coalition for Social Justice. I lead up our criminal justice reform work, where we are looking to end mass incarceration and the attendant second-class status that comes with having a record in the South and hopefully across the southern region. Quick slide about us and who we are. We are a civil and human rights advocacy organization premised under a community lawyering model, meaning that basically we serve as general counsel for the most vulnerable communities across the state. We're multidisciplinary and multi-issue. We work on voting rights issues, criminal justice issues, environmental justice, and a catch-all bucket called human rights, which gives us a little bit of flexibility to address community concerns. Because what we found in our 7-year history, the same community where they're trying to racially gerrymander their voting district is the same community where police are over-policing and engaging in stop and frisk. It's the same community where they want to cite the mega landfill or the pig farm. So we have to provide these communities a toolkit where they can advocate both on multiple issues using multiple advocacy strategies. So, over-criminalization, and Doug laid out some of the data in Georgia. This is some of the data nationally as well as in North Carolina. The breadth and the scope of our criminal justice system is just too large. We are 65 million people have criminal records. We arrest about 14 million folks a year. North Carolina, that's 1.6 million people with a criminal record. That translates into 1 in 6 adults over the age of 16. So some of our folks who are on the call might quizzically scratch their head and say, why would he say adults over the age of 16? Because North Carolina is one of 2 states in the country that prosecutes children. And I'm very specific with my language. Children automatically, 16 and 17-year-olds are prosecuted automatically as adults, whether it's misdemeanor or felony. And we saddle those young people with criminal records that act as a millstone to thwart their ability to employment, education, housing for the rest of their lives. I'm sure everyone on the call are familiar with the civil disabilities that are triggered once you have a criminal record. Nationally, they are roughly anywhere between 45,000 and 50,000, and there's a link to the American Bar Association site where you can look at what the civil disabilities are in your respective state. In North Carolina, we created a tool that really was the template that the Bar Association tried to use to do this work across the country. We have about 1,200 civil disabilities. These are formal, statutory, or regulatory restrictions that are triggered as a result of your criminal justice involvement. But you also have informal barriers, you know, the infamous box, if you will, that you have to check because you have criminal record history. And what has become more and more known in recent years, particularly around the work that the Attorney General Holder's Federal Interagency Reentry Council has done, as well as the Access to Justice arm within the Department of Justice at DOJ, they've really amplified the need for civil legal assistance and how it actually facilitates successful reentry. And so when we think about Gideon and the Supreme Court case that mandated that we provide poor people who are accused of a crime an attorney, irrespective of what you may think about that attorney. A constitution mandates that an attorney be provided at that stage. We don't do that once someone has gone through the system, irrespective of whether they went to prison or jail, but once they've gone through the system, we don't provide them with a lawyer to navigate the thousands of collateral consequences that are triggered. And as a result, people continue to bump up against barrier after barrier after barrier. You know, I didn't come to this work because I woke up one day and said, you know, I want to go help people, you know, re-enter society, and I don't knock anybody who comes into the work for that particular reason. I came to this work out of my own personal experiences. I was convicted of a first-time nonviolent drug crime in 1996, spent 40 months in prison in the Alabama Department of Corrections. But my prison experience was really a blip on the radar screen of life. It was the civil disabilities that I encountered once I was released. So my driver's license was automatically revoked. I couldn't vote. I was denied federal financial student aid as well as admittance into universities and several law schools. So I hit barrier after barrier after barrier, and I did not have anyone to advocate for me in overcoming those particular barriers. So once I was able to break through and get my law degree and move to North Carolina and become licensed, I said the practice area that I want to establish is this back-end legal support for people who had been through the system. And so that's where we began our criminal justice reform work at SCSJ. That's kind of a slide illustrating how we think and how we, you know, message about our clean slate model. The link on the slide is a pre-registration link that we encourage our participants to do. So when we have a clinic, folks can pre-register. We get the critical information that we need. So when we go to a mobile site to do a clinic, we've already pulled their background. We have a retainer agreement already made. We have whatever expungement or certificate of relief petition that they qualify already prepared and ready. All that person has to do is come give us their John or Jane Hancock, and then we're ready to file. So what services do we provide? We provide expungement, erasing services. I do want to point out that in the state of North Carolina, and I don't know if it's like this in other states, that our expungement laws apply to official records, meaning our Administrative Office of the Court records, our State Bureau of Investigation, and any local law enforcement agency that may have a record of someone's arrest or conviction. However, our North Carolina Administrative Office of the Courts sells criminal record information to third-party data providers. the expungement statutes don't govern those third-party data providers. We've tried to get some legislative fixes around that particular problem, haven't quite wrestled that animal to the ground, but we're continuing to work on it. There are federal remedies under the Fair Credit Reporting Act, but once again, you're asking a poor person to have access to federal district court. Anyone who does that litigation knows how cost prohibitive that can be. So it's essentially a non-remedy for most folks. So we do expungements, certificates of relief, representation before occupational licensing boards, whether if you want to be a barber or a cosmetologist or electrical contractor. We represent people before those licensing boards to ensure that they have a voice, to help them get the requisite licensing or permits that they need to be able to engage in a given vocation. We also do driver's license restoration. Public transportation is terrible in our state. As a result, if you don't have a driver's license, your employment search is literally limited to a 3 to 5 block radius. As a result, we do that work to ensure that people can have access to a greater employment search capability. We do Title VII EEOC charges when people have been discriminated against because of their criminal record, as well as Fair Credit Reporting Act intake and referrals, and we're looking to partner with a couple of firms who are going to help us do that litigation. The next slide is just a picture of me at one of our clinics, and we host them across the state. We partner with reentry and social service providers in those respective areas, but I do want to point out that the legal services are only part of the puzzle for us, because 50% of the people who we come in contact with, and we will have 500 people pre-registered, right? And only half of them are going to be eligible for some kind of expungement or certificate of relief service. But we don't want those people feeling like, I have no hope. So we do voter registration. We help identify what our policy agenda should be by listening to directly impacted folks and them informing us what we need. We also do leadership development by identifying leaders who can be the initiators of local campaigns, community organizing, and lastly, we are collecting stories from directly impacted folks, because we have to shift the paradigm of who people think of when they think of someone who's committed a crime. These are mothers, these are fathers, this is the person who's sitting next to you in church. This is a viable community member who wants to contribute. And until we tell those stories, until we change the face of who people think of who's committed a crime, we're going to be stuck with these very limited relief options because people don't see themselves in that story. And so I'm going to stop there and open it for some Q&A.
Great. Thank you so much. And thank you all we have just terrific panelists, and I hope that the audience members really enjoyed these as much as I did. And we do have some questions coming in. And just for you all who don't know me, I'm Michelle Rodriguez with the National Employment Law Project. I'm an attorney there and have the privilege of working with the New Southern Strategy Coalition. So we have about 5 minutes for questions, so we're going to get to a few of the ones that folks had. We won't get to all of them, but we will be emailing out the slides and a recording of this webinar after the webinar is completed. So the first question we have, this is for Caryn. So Caryn, we did have a question come in about the petition for being within 8 years of the arrest. If that doesn't happen, does that mean the remedy is gone for good?
Unfortunately, yes. That's how the statute is written. If you were arrested and not charged and you let the 8-year period run out, then you have pretty much exhausted your opportunity to remove that from your record. How we came up with that 8 years, I'm not sure. Yeah, the answer to your question is that it must permanently remain on your record.
Thanks, Caryn. Yeah, that does actually sound really tough. We do have another question. This is for Doug and Daryl specifically, but if others want to chime up, please do. And that's how can organizations get legal help for their clients? Thinking about, the questions that we were talking about today, the issues of expungement. What are some of the places that folks can look to for legal assistance?
I guess I'll weigh in. Most states have some form of legal aid, legal service corporation-funded organizations. And all of the recent second chance grants, as well as the Department of Labor grants, they have specifically enumerated that legal services can be paid for via these Second Chance Act grants. So that's a way that they can get paid for. And, the New Southern Strategy Coalition, what we want the ability to do once we build additional capacity and actually get some additional funding in the door is to be able to go do teach-ins, if you will, on how you can build legal service models to do these reentry legal services across the South.
This is Doug, and Daryl, that's great. I would have said the same thing. One other thing I would add is we have a member of the coalition is in St. Louis called the Arch City Defenders, and they've done a great job of being creative, recognizing those funding opportunities inside federal grants and going to the groups that got the grants and saying, hey, did you know we could represent your people? You could pay us to represent your people on restriction and expungement issues. So that's another creative option.
And another question specifically about what the New Southern Strategy Coalition could do. How can the coalition help build capacity for your organization? And this is open to anybody who wants to chime in.
This is Caryn with the Job Opportunities Task Force. So in Maryland, it's very interesting to see how legislators react when we offer information on what other states have done. Many times, many of the examples that we present to legislators as far as look what other states are doing in terms of restricting access to the record, we tend to, of course, choose those examples that have more far-reaching laws than we are trying to propose or advance in Maryland. And more times than not, most states that do have some type of relief law on the books, their laws are more far-reaching than Maryland. So I think that it's really important for different states to stay in touch and to update each other on what different reforms are taking place, to offer suggestions and assistance on how they can use those efforts to their benefit in their respective states.
Thanks, Caryn. And we have just about a minute to go, so I just want to leave this on a note of conclusion, and that's just any lessons learned from your experiences in this area, panelists, that you want to leave the audience members with.
This is Roberta, and I'll be quick. I think the lessons learned is you do not have to recreate the wheel. Any ideas that you have regarding dealing with expungement in terms of helping to build up legal capacity in your community or in changing the law, look to groups in neighboring states and partner, share information. A lot of these organizations that are on this call now have tools and information, and definitely through the coalition that will be available on the website, you can get some of this information, and through the National H.I.R.E network, get this information and use it and get ideas and strategies that you can use in your state.
Thank you so much, Tony, and thank you all for participating today. And that's the end of today's webinar. We look forward to seeing you all again